case briefs, and so much more. LSData's got what you're looking for.
In the 1999 Court of Appeal of the State of California case, Pruitt v. General Motors Corp., Norma Pruitt challenged General Motors Corporation, GMC, after sustaining injuries due to a purported defect in her 1991 Chevrolet Beretta's airbag design. Pruitt argued that during a low-speed collision, the airbag deployed, causing more harm than she, as a typical consumer, would have anticipated. During the original trial, the jury was instructed on the balance of risk-benefit and the necessity of a warning, but not on the consumer expectations test. Pruitt's conviction was that this particular test should have been included in the jury instructions, aiming to shed light on what an ordinary consumer would expect of the airbag's performance. Her claims were bolstered by her personal testimony, stating that she didn't expect the airbag to have harm-causing potential. Despite Pruitt's argument, the jury ruled in GMC's favor, identifying no design defect or failure for suitable warning. The jury's decision was buttressed by the trial court's exclusion of evidence tied to post-manufacture warnings. On appeal, the court reasoned that the consumer expectations test is only applicable if a product's design violates minimum assumed safety standards, a determination that typically doesn't necessitate expert testimony. The court further indicated that, with more complex design issues, a risk-utility balance must be maintained, which allows for expert testimony to clarify potential design defects. Upholding the trial court's judgment, the appellate court backed the argument that issues regarding airbag deployment extend beyond the common knowledge of an average consumer, requiring expert input to assess the safety and efficacy of the design. As such, costs were awarded to the respondent, GMC.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.